During opening arguments in your trial, in your medical malpractice trial, can the defense attorney turn to the jury and say, ladies and gentlemen, Oginski and his client are being so damn greedy, we can't settle his case? Can he do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, he cannot, under any circumstance, tell the jury about anything that went on during settlement discussions before we actually got to trial. If he were to do that, that would destroy this jury's impartiality. Now he will have poisoned the jury to think that we, as the plaintiff, as the person bringing the lawsuit, are being greedy, without knowing what the true value of your injuries are, without knowing the true extent of the damages, without understanding this case at all. In opening arguments, the defense comes out and says, hey, listen, Oginski and his client are being so damn greedy, they want millions and millions of dollars, and you haven't even heard any testimony or any evidence yet about what his damages really are. Can he say that? No, he cannot say that. And if he were to say that, you know what I would have to do? I would have to jump up out of my seat as if somebody pressed an ejection button and yell out, "Object, Judge! I ask for a mistrial! This is outrageous!" The defense attorney knows full well he is prohibited from telling the jury about any settlement discussions that went on at any time in this case. And now I'm at a significant disadvantage. Now my client and I are prejudiced because now he has put in the jury's mind that we are being greedy, when in fact we may be entirely reasonable based upon the horrible injuries that my client suffered, all because of this doctor's carelessness. In that instance, I would be entitled to a mistrial. I would be entitled to an instruction from the judge that this is entirely inappropriate behavior. Now, why is that? I'll tell you why. It's because when this case goes to trial, we're basically asking a jury of six people in the community, to reach a decision, to decide whether or not this doctor was in fact careless, to decide whether or not his carelessness was a cause of your injury, and if so, how much money you are to receive as a form of compensation for all of the damages and the harms and the losses that you incurred because of his wrongdoing. That's what the jury is there to decide. The jury is not there to listen to accusations about what went on during settlement discussions. Instead, they are there to decide whether we are slightly more likely right than wrong that what we are claiming is true. That's their entire purpose. So now, if the defense attorney goes ahead and tells the jury about anything that happened during settlement discussions, boom, I make an objection. Now the judge has to make an immediate ruling. And if he decides that, yes, the defense should never have mentioned this, guess what? Now this jury is going to be excused and the attorneys are going to be directed to go back downstairs to the jury room and pick a new jury and start all over again. So why do I share this quick information with you? I share it with you because this comes up from time to time where an injured patient turns to me and says, listen, I know we've been trying to settle this case for a few weeks now. What happens if the defense goes ahead and tells the jury about these efforts? Will it destroy our case? Will they begin to know what went on behind the scenes? The answer is no, they won't. So why do I share this with you? I share this with you just to give you a real insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and these wrongful death cases here in New York. You know, I do understand that you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking about bringing a case, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.